renovation and efficiency. And their goal is to combine within communities at a microcosmic level to start a prototype where you could combine owners, contractors, social service agencies, and families that need housing to identify particular units that can be rehabbed and made available. There are a lot of challenges to their idea, and I think the judges were impressed with the fact that this is one of the major issues in our city today, and that here are some people who are really committed to thinking seriously about another way to get at a niche of that problem. Jared Brenner described his own wiki to those of you who were upstairs at lunch. The whatif.wiki will create a new digital legal innovation commons for the exchange of ideas between entrepreneurs, law students, academics, practitioners, and other interested observers. And I'd like Jared to come up so we can all give him a round of applause.
Hey guys, thank you. I kind of gave away the store already upstairs, but for anyone who wasn't up there or was otherwise distracted, my basic idea is to create this wiki site, an encyclopedic collection of these various policy ideas we're always talking about where the law is not keeping up with the needs of innovative new ventures. I think there's a lot of potential to grow a community on there and to link together a lot of people in different cities across the country and maybe even beyond this country who are thinking together and working towards solutions to these problems. That's the ultimate long-term goal of the project, is to be able to crowdsource new policy solutions, new legislative proposals, and discuss them on one platform. So I'm going to be starting to build the core team here at Brooklyn Law School in the summer, I'm hoping. Those of you here who are students, if you're not graduating or even if you are and you're interested in getting involved, I'd love to talk. Anyone else, practitioners, alumni, other attendees here, if you have any ideas to contribute to the project, I'd love to talk about that as well. And for anyone out there in the world, I'm at Jared Brenner on Twitter. You can reach me on there. Thanks so much.
So Brooklyn Law School is committed to working with Jared and each of the prize winners to help them make their projects a success. And next year, when we have the second annual CUBE Innovators Competition, in addition to hearing some new proposals, we'll get a chance to hear reports of how it all worked out.
Thanks. Paul. I gotta say, what I love about each of those winners is that each of them fits into one of the panels or demos or workshops we've had today, if you think about it. We got the one where you drop your coins at the courthouse. Maybe it's not crowdfunding, it's perhaps crowd unfunding, but there may be a seat at the table for them next year. Second one, the shared one, they've been a perfect panelist in the technology for access to justice discussion. And Jared's, we already pointed out, would be a perfect platform for the creation of the Citizens Charter for Cyberspace. So as you develop your ideas, always think about your niche, the place you fit in. I think it's pretty clear. Sometimes you may be thinking you're doing something in a vacuum, but other people are thinking about similar ideas, maybe with different permutations, different tangents. But there are ways to connect it, and you should always be thinking about connecting those dots. Now, those are the students that just pitched their ideas, and they're going to spend this year building out those ventures. We've also got a few students, a bunch of 3Ls, who have already spent months, if not more than a year, developing some interesting ideas and platforms. And we want to spend a few minutes, just 15 minutes, 5 minutes apiece, for them to give a lightning demo on the ideas that they've been incubating. Some grew out of hackathons, some grew out of some class assignments, some grew out of just conversations that happened when we experienced the adjacent possible. So our first one, group is a group of 3 students who built a project over a weekend. February 8th and 9th, we held our data privacy legal hackathon in London, in Brooklyn, in San Francisco. And I'm embarrassed to say, this is my favorite. They did not win. They did not win, but if they were they spent the past 2 months working on it, building it out. I think they should have won, but that's maybe my own personal biases. In any case, we had a hackathon back in January in which we were concerned about a concept called revenge porn. Raise your hand if you've heard of revenge porn. We're not quite the demographic, but it is becoming more and more prevalent, a huge problem. California and Maryland have instituted statutes combating revenge porn. They may not survive constitutional scrutiny. The students have picked up on some scholarship from a former Brooklyn law professor and have now decided they were going to build a platform to combat revenge porn using the Digital Millennium Copyright Act. So why don't you folks take it away?
Hi, so my name is David, this is Austin, and this is Sarah. I'm going to talk to you today about the problem of revenge porn. Cool. For those of you who may not be aware, revenge porn is when you send, your lover effectively an explicit sort of naked photo. And when that lover perhaps one day is not so much your lover anymore, and they upload it to a website. There's a number of websites who specialize in these types of photos, myex.com being one of sort of the most famous of these. Sometimes these photos are attached with the name of the victim, as well as their Facebook link and their address. This is a problem that, while skews toward women heavily, could affect anybody. In addition, this is not so much as only affecting someone's reputation. It can affect their economic well-being, as well as provide amazing, as one can imagine, emotional harm. This is also a huge, widespread issue. A 2012 Pew survey found that 1 in 4 adults had either received or sent one of these explicit photos, so was at victim of could become a victim of revenge porn. The solution. As Professor Askin said, while a number of states have passed sort of laws criminalizing it, there are questions as to the validity with First Amendment issues. In addition, the rights of privacy, publicity, as well as intentional infliction of emotional distress are torts that are hard to do and hard to sort of prove. In addition, none of these remedies actually take down the photo. All they do is penalize the person who might have put up the photo. We have a new solution. Austin?
Thanks, David. So as Professor Askin was saying, we held an event about this. We were concerned about the lack of law on this issue, specifically the effective law. So we built a solution leveraging the ubiquitous selfie. So as you know, maybe you don't know, selfies are pictures that the subject of the picture takes of themselves. It's a pretty straightforward concept. According to the Cyber Civil Rights Initiative, which is the leading authority on revenge porn, 80% of revenge porn victims take the photographs of themselves that are posted online. So we also know as lawyers that the photographer of a photo, unless otherwise contracted, owns the copyrights in those pictures. So the Digital Millennium Copyright Act, as Professor Askin said, enables copyright holders to request the removal of the infringing photos. And if the website would like to keep the liability shield afforded to them by the act, they must comply with the request, otherwise face potential liability. So our solution, using copyright as an approach to help victims immediately. The DMCA notice system offers victims the potential for an immediate solution, which any kind of privacy law solution does not under current regimes. And so there are other added benefits to this. Most internet users don't know the fact that they own copyright in their selfies. So we corrected information asymmetry in that way. Similarly, they don't know that they can use the DMCA notice and takedown system for pictures that they've taken of themselves or of other people, and it also helps victims in that way. So we created a system, a working online system that's up right now in beta form, providing victims with the instant ability to issue these takedown notices and draft them. And Sarah's going to demo that for us.
Thanks, Austin. So our mission in developing this website, which we want to mention is still in its beta phase today. There's a few things that we need to work on, but it is fully functional. Our mission in developing our product was to provide revenge porn victims with a platform in which they could use this website to take down the photos that are spread all over the internet. Every hour, every day, every minute really that these photos are placed on the internet, the victim of revenge porn is experiencing reputational harm, potential career harm, and harm in their relationships as well. So our mission is to mitigate these effects.
Yeah, right there.
So the first step in sending a takedown notice here is to provide the website with biographical information. This information will only be used as contact throughout the DMCA takedown process should it be needed. Now the next step is arguably the most challenging for us and the most challenging for the victims of revenge porn. This is to identify the infringing website and the specific contact for that infringing website. Now this becomes difficult because owners of these websites don't want to be found, they don't want to be located, and they often change their specific contact information. So what we're hoping to do is develop an algorithm which will allow us to pull the specific data and contact information at the time the DMCA takedown notice is actually sent, and therefore we can ensure its accuracy. The next step is to upload the original photograph. And to preempt any privacy concerns here, this photograph will be deleted as soon as the DMCA takedown notice is actually sent. On this page, you'll also see that it asks the user to ensure that they took the photograph of themselves. As Austin spoke about, this is a selfie, and there is no debate as to whether or not the user or the victim in this case owns that copyright. Again, this is just to ensure that the correct photo is up and to make sure that the user is acting in good faith, which is a requirement throughout the DMCA takedown process. This just verifies that it's being sent. A copy of this will be sent to the user, the victim, and the allegedly infringing website. Our final product is an official DMCA takedown form that's populated with all of the information that the user specifically uploads into this. You'll see the website, and you'll see a description of the photo that the victim has uploaded. We just want to send a special thank you to Mark Olblad, who without his help with coding this website during the legal hackathon, this project wouldn't have been possible, and to Professor Askin for all of his support throughout this process, and we really hope that this ends up helping the revenge porn victims. Thank you.
Thanks. I got one question for you all. Is Elisa from Glimpse still in the audience? Elisa, are you still here? No, I think she may have left. Do you if I was uploading to your site, I'd be potentially equally scared to upload my photo to your site. I don't know who you folks are. Do you think there's a secure Snapchat or Glimpse-like capability that could be built in on the uploader side so that their photo doesn't rest with you in perpetuity?
Yeah, absolutely. Yeah, there's already a mechanism involved that deletes the photo, but obviously we want to ensure that we don't keep anything that would allow any victim to become victimized again. So obviously it's a key part of the website, and obviously we want to work with anyone to improve upon that and also to improve upon any other aspects.
Yeah, we actually built, just wanted to say one thing, we actually built privacy by design measures into the product. So the images after they're uploaded are destroyed by the system and they're not cached. So the only place that the images are actually being stored are in the outbox. And if the outbox is set to delete upon send, then it's strictly privacy by design. There's no chance of the images that they upload ever being leaked.
I think this is wonderful. I think this is a great example of soon-to-be attorneys using technology, the internet, innovative tools to do that which the Constitution and the law possibly do not allow.
Thank you.
Thank you. On that note. Great. Our next demo is more than a year in the making, a year and a half in the making. So Gabe was a student in the Bleak Clinic last year and spearheaded a concept. This was, who's familiar with the American Invents Act? Most of you. Actually, Gabe, you're going to talk a little bit about the history of the American Invents Act and why and the launch and all that.
I'll mention it briefly.
I'm leaving it to you.
Hello, my name is Gabriel Goldenberg. I'm a member of the BLIP team that created FirstDisclose.org. FirstDisclose.org is a website to allow inventors to publicly disclose their invention so that everyone has access to it and sees it. The BLIP team I was a part of created FirstDisclose.org in anticipation of the change in the IP framework that the American Invents Act would put into effect on March 16th, 2013. And what the American Invents Act did is change the patent system from a first to invent system to a first to file system. What that means is the first person to hand in their application to the USPTO would get credit for the invention instead of the person that could prove that they were the first one to come up with that invention. So with the American Invents Act, there were inventors could create pre-filing disclosures, which would start the 1-year grace period, which would allow them to complete their patent application process. Another use is defensive disclosures, which would allow the inventor to publicly identify their invention so that another company can't then go and patent that invention, then prevent other people from using it or require licensing fees. What first to disclose allows people to do is upload these inventions for free. Patent examiners and other people could search those disclosures for free. It's easy to use, just like most of the popular websites out there. It's built on the WordPress platform, which is familiar to a lot of people. The other benefit of it is that it creates a sort of standard for these types of disclosures. A disclosure, once it's uploaded, is date stamped so that there's no argument about when the disclosure was made. And it's also centralized so that people know to come to First to Disclose to search for these disclosures. This is an alternative to someone just posting it on their website or other websites that allow them to post any sort of internet content, because depending on what search engine algorithms are doing that week, you may not be able to find that particular disclosure or invention, or someone might make changes to that website and your disclosure will be lost in history. So I'll just briefly show you First to Disclose, and I'll let you know about our progress. So far, First to Disclose has submitted a comment to the USPTO recommending that they consider using this as a tool for patent examiners to examine prior art. We're also constantly soliciting feedback from the IP community to make this an even more useful tool. I'm not gonna go through all this. It's an active website. You're welcome to do this at home. You would make a disclosure by going to Submit Disclosure, and you'd be able to search disclosures by going to Search Disclosures. So this project is only useful if the legal community and the inventor community starts using it. This was a project that was bootstrapped by a couple of BLIP members and by Professor Askin. So we're looking to the legal community, the inventor community, to spread the word and encourage inventors to use this if this is the right option for them. Thank you.
To me, I think it's going to be most advantageous for those of you from the Information Wants to Be Free camp, the open source free culture community. A great place to share your ideas and not allow anyone else to actually claim the idea. That's probably its most efficacious use. Our last student demo is by way of entree into our next panel. So Boyan and Alana, come on up. They've been working on something called the B-Corp. They've been working on it for a while now, and so this has been in a sort of perpetual beta state for a while. We hope that at some point it will see the light of day and be a useful tool for socially responsible, internet-oriented enterprises.
Yeah, how do we presentation. I don't have a link to yours. Let's see. I don't think one of these, right? Any of those?
While they're setting that up, I'd like the next panelists to view this with a critical eye. If time permits, we could dissect this a little bit. I know some of you have thoughts, more mature, seasoned thoughts on what the future of the social entrepreneur looks like. So we'd like to know, get your take on how this might fit into the evolution of social enterprise.
Right, so let me look here. It's,
We could just talk, I guess. It's nice if I have to show visuals.
sure, let's,
While we're waiting, anyone have any thoughts or comments they want to share? Any issues? Yes. Eric, you want to yell or you want me to bring? I'll bring it back.
can you see it?
And I was thinking, wouldn't it be neat and maybe even a little more useful if, when you submit your disclosure to First to Disclose, there's a button you could click that would also file that disclosure as a provisional patent application with the PTO, so that if you weren't sure if you wanted it to be public or not public, you didn't have to decide then, you could put that off for a year.
Gabe, you want to field that question? It's a great question. Eric, we should have used you as an advisor on the project.
I have a patent on that.
Don't we have a retainer with you? Aren't you an official mentor to the Blip Clinic? All right.
So I think that is a great idea, and that is the type of feedback that we're continuing to solicit. We're working with some large companies and getting feedback from them now that are considering using the system. And we're trying to implement things like that. So I encourage all of you to contact us and work with us to make this the system that it seems like the community needs.
And by the way, before I hand it over, I do want to point out that if it weren't for me, that guy who just spoke in the back would probably be about a billionaire at this point. He was one of our first Blip students, always had what I thought was a crazy harebrained idea. 3 years later, every single one of his ideas, someone had built and sold. Whatever it was. He left his firm at King & Spalding and is now embarking on his own law-related entrepreneurial venture. Again, against my better judgment. No, but when you make $1 billion, don't forget us. Anyway, I'm going to hand it off to Alana and Boyan.
Sorry about the delay. I'm Alana, and this is Boyan. We're going to talk to you today about G-Corp, which is a set of third-party certifying standards that we've been developing along with another organization called Goodnick for socially responsible internet-based startups. So, Boyan and I are in the Blip Clinic, which, as you may know, provides legal services to startups. We are on a team that Professor Askin has coined the Leonardos from Ninja Mutant Turtles. And we're the do-gooders. That's sort of the theme of our team. We're the ones who help the nonprofits, the startups who want to do good. And for a lot of the startups that we've been working with, they want to find a way to be able to show the community that they're not only trying to make a profit, but that they also want to serve the community. And this is where G-Corp comes in. And I know a lot of you might be thinking, well, doesn't B-Lab do that? Doesn't B-Lab provide these third-party standards for socially responsible ventures? And that's true, and B-Lab is great, but it doesn't necessarily fit the model for small internet-based startups for a couple of reasons. First of all, for these small organizations that maybe have one or two co-founders, it might be a little unaffordable for these individuals. And also, there are a lot of new and interesting ethical dilemmas that face these organizations that they want to be able to voice that they're accounting for. So things like data privacy, transparency, and open sourcing are things that these organizations want to say, we're looking into it and we're practicing ethical practices when running our startup. Now, a lot of what G-Corp will be accounting for are the basic social standards similar to B-Lab, things like philanthropy, anti-corruption and whistleblowing, environmental impact, and fair compensation and wages. What's particular about G-Corp as well is that the bylaws that we've developed for them are ones that meet the size of the businesses that are at hand. So for example, for philanthropy, there is a requirement that we ask for companies to develop in their bylaws to contribute some philanthropic efforts, whether it's their time or whether it's some of their profits, but it's based on a percentage of what their business earns, which makes it affordable and reasonable for smaller businesses.
As Alana mentioned, a number of our standards are geared towards the technological and the consumer-facing treatment that companies, the way that companies treat their consumers. So those standards include intellectual property. So we want companies to open source and to only use their patents and their intellectual property defensively. We want transparency, so we would like companies to be as open with their consumers about their business processes and their data usage as possible. We want them to honor consumer rights. We want them to treat consumers fairly and to make sure that they protect their rights of free speech and association. We want them to have strong data privacy and security protections. And finally, as much as possible, commercially possible, we would like them to open source their software. So the way that companies will participate in our standard would be one of two ways. So they would either self-certify to adhering to one or more of the principles that the standard sets out. That wouldn't qualify them for a full certification as a G-Corp. What would qualify them would undergoing an outside audit. And of course, since we're gearing this towards young companies that don't have a lot of money, the model for this would be ideally one with very small fees for outside auditors, and probably one managed by Goodnick, which is the nonprofit that we've been partnering with that would be running the G-Corp model ultimately.
Thank you.
That's terrific. Thanks a lot, folks. Now, I assume you're aware that we actually do have a representative from B Labs in the room and who will be sitting on the next panel. I suspect she may have some good insights into what you've done and what B Labs is doing and how they may work with startups. In any case, I'm going to hand it over to Dana and the social entrepreneurship panel. We're fortunate at Brooklyn